I am Salty. I'm the co-president along with Austin Moore, and this is our board. And so to introduce our speakers today, we'll start with Professor Jones, because most of you know him probably. He is obviously an assistant professor at NIU College of Law. He got his JD from New York University School of Law. And then he will be debating Josh Blackman, our guest speaker, who is an assistant professor of law at South Texas College of Law. He got his JD from George Mason School of Law. He was recently admitted to the United States Supreme Court.
Whoa!
Yeah!
These guys do their homework.
And he was ranked by Forbes magazine as top 30 under 30 in law and policy. So we'll get started.
All right. Good morning, everyone. How's everyone doing? I welcome everyone. Thank you so much for having me. I tried coming here in October, November, and due to the snow, the event was canceled. So I appreciate everyone at the chapter here making this happen again. Excuse me. Today we are going to be discussing the case that we argue before the Supreme Court in about 2 weeks, United States versus Texas. This case considers the legality of President Obama's executive action on immigration, known as DAPA. DAPA stands for Deferred Action for Parents of Americans. So at the outset, I'd like to discuss what I'm not discussing. This is not a discussion of immigration policy or any of the sort. In fact, I support the president's immigration policies. This will be a discussion of whether his policies are constitutional. That is, whether DAPA is consistent with the president's duty to take care that the laws are faithfully executed. So to begin, I'd like to give you an overview of what came before DAPA, what DAPA is, what are Texas's arguments in favor of the law's unconstitutionality, what are the United States' defenses of the law, and to give my own opinion, which reflected in an amicus brief I filed today on behalf of the Cato Institute for the Supreme Court. In fact, the PDF was filed about an hour ago. I haven't even seen the final proofs, but I assure you it's a good brief. So to start, immigration has long been a very contentious and divisive issue in this country. And during the first few years of President Obama's term, there was a push to enact something called the DREAM Act. The DREAM Act would have provided a pathway to citizenship for certain minors who are not citizens and who came to the United States before their age of majority. This bill actually passed the House of Representatives, but it was defeated in the Senate. 6 months after the DREAM Act was defeated in the Senate, President Obama announced the first of his executive actions in immigration, known as DACA, D-A-C-A. Now make sure you got DACA, which is Deferred Action for Childhood Arrivals, and DAPA with a P, Deferred Action for Parents for Americans. Try to get them straight. So DACA, to make clear, was not amnesty. It did not provide any grant of citizenship. What it did provide is what's called deferred action status. Now, deferred action effectively means that the government tells an immigrant, we are putting you at the bottom of the list for removal, right? They don't tell them we're not going to remove you. It simply says we're not going to prioritize you up top. Now, practically speaking, there's a 0% chance of this person being removed unless they break the law or do something really stupid, but they're probably not going to be removed. As a consequence of giving someone this deferred action status, the person also receives work authorization, eligibility for Social Security, eligibility for Medicaid, and a whole host of federal benefits. Okay? Roughly 1.5 million of so-called dreamers were eligible for relief under DACA. Okay? So that's the first one. Fast forward till 2014. You may recall that the Senate passed what's known as a Comprehensive Immigration Reform Bill, or maybe as it's better known because of Marco Rubio, the Gang of Eight bill. Okay? This bill would have again provided a pathway to citizenship for about 11 to 12 million aliens in the United States illegally. This bill actually passed the Senate due to the so-called Gang of Eight. Now, as we all know, bills must go through both houses. So then the next step was for the House of Representatives to vote on the comprehensive immigration bill. However, the House Republicans and Speaker Boehner said, we are not going to bring this bill to a vote, and the bill died. Excuse me. A few hours after Speaker Boehner announced that he would not bring to a vote the Comprehensive Immigration Reform Bill, President Obama gave an impromptu conference at the Rose Garden in the White House. And he said, and I'm paraphrasing here, when Congress doesn't act, I will act, right? I will take action when Congress doesn't address serious issues. So over the course of the summer of 2014 and leading into the fall of 2014, rumors swirled that the president was hatching this executive action that would provide some sort of relief to the immigrants who would have otherwise benefited from this Gang of Eight bill. Quiet during the summer, quiet during the fall, and then the election happens and the Republicans gain more seats in the Senate and the House. 2 weeks after the midterm elections in 2014, President Obama announces the policy that became known as DAPA. Okay? So while DACA provided deferred action to certain immigrants who came here as minors and were not here legally, DAPA sought to provide deferred action to two primary groups: the parents of U.S. citizens and the parents of LPRs, lawful permanent residents. Okay? Now, as you all know, by virtue of the 14th Amendment, if a person comes to the United States and they're born on U.S. soil, they are a U.S. citizen by birth. Their parents, however, are not. And the law imposes a series of obstacles for the child to petition for a green card for their parent. Namely, the child must be 21 years of age before they can petition for an adjustment of status to their parent. So there's a significant gap between when a U.S. child is born and gets citizenship and when that child can then petition for a green card for their parent. Okay, so what does DAPA do? DAPA says if you are the parent of a U.S. citizen or an LPR, and you haven't engaged in any criminal acts, and you're generally a good person and whatever else, if you apply for this program and you pay a fee and other things, we will grant you deferred action status, and with that comes work authorization and Medicaid and all these other federal benefits that come along with that. Okay. This would affect roughly 4 to 5 million aliens in the United States. The exact number is entirely clear, but somewhere in that ballpark, right? That's roughly 40% of the number of the illegal population in the United States. Okay, so what happens next? About 2 weeks after President Obama announces DAPA, the state of Texas, where I live, filed a lawsuit challenging the legality of DAPA. Now, they made 3 primary arguments. I will only be talking about the last one. The first argument is that this was a violation of the APA procedure. That is, this was not a guidance document. This was a formal rule that would need to go through the notice and comment rulemaking process. Second, they argued that this was actually substantively unreasonable under the APA, that the statute did not delegate sufficient authority to the president to engage in his act. Okay, not going to talk about the APA either. The third argument, which was the interesting novel one, is that DAPA violates the president's duty to take care that the laws are faithfully executed. This is in Article 2 of the Constitution. Okay. Now, in full disclosure, I filed a brief in support of Texas at the district court. I filed a brief in Texas in the circuit court, and I filed a brief in support of Texas at the Supreme Court. I went the distance. I batted the cycle, so to speak. It's opening day today, so I get the baseball jokes in. So I have taken several positions on this, and you can read my briefs later if you want to check those out. But the long and short of my argument is that the aspect of DAPA, which effectively defers deportation for millions, amounts to a suspension of the law. Now, I'll give first the arguments that the government says to defend this. The government makes a point that I absolutely agree with. They do not have enough money to deport everyone who's here in violation of the law. They simply don't. Congress only appropriates enough to deport roughly 400,000 people a year. We're looking at a total population of 11 to 12 million, maybe more. We actually don't have an exact count. So it's certainly true, without a doubt, that the president must husband his resources and economize and decide how best to spend the limited resources that Congress gave to him. And I don't dispute that for a second. DAPA is different, though, right? The reason why DAPA is different is because the president is attempting to achieve a policy that Congress expressly and explicitly rejected. The key aspect of the Take Care Clause is the word faithfully. The president shall take care that the laws are faithfully executed. And if you go back and you read the Constitutional Convention debates, which I encourage you all to do, there was a big debate about how to frame the Take Care Clause. And indeed, it was the Committee of Style, staffed by people like James Madison and Alexander Hamilton, who made a strong focus that the key word should be faithfully. And what does this word good faith mean, right? What does this word faithfully mean? We know what faithfully means in the context of contracts, okay? The concept of good faith goes back to the time of the Romans. This is a very well-established doctrine that's existed for, since the times of antiquity. And as you study in contracts in your first year, the general notion of good faith is that you have discretion when you're executing a contract, but your discretion is bounded by the expectations of the parties when you began that contract, right? If you try to use some sort of discretion given to you to frustrate the purpose of the contract, you are no longer acting in good faith, okay? So what does that mean for our case today? The president sought relief for immigrants to defer the deportations, to have them granted citizenship, and whatever else. Congress, for better or worse, in my opinion, it wasn't for better, voted against this bill. They voted it down. For the president then to come around and say that the exact same authority that Congress just withheld has now magically manifested, right? It's not the granting of citizenship, make that point clear. But this was means to bypass the laws that Congress has. And in my remaining time, I actually want to get into the statutory framework, because there actually is immigration law. There's something called the INA, in which Congress has expressed certain policies and preferences. So for example, deferred action has been used a number of times in the past by presidents to halt the deportation of certain groups. And I'll give you a very easy example to see how this usually works. So say you were a student at Tulane University in 2005, okay, in New Orleans. Hurricane Katrina struck the Gulf. All of the colleges shut down, right? The entire Gulf was shut down. If you were a foreign student and you were on a student visa, guess what? You are no longer here illegally. Because you're not maintaining your credit load, your student visa now is void. So would it really make sense to deport all the students in New Orleans who can then just go and re-enroll in another university the next semester? So what did President Bush do, which I think was probably a good idea? He said, look, if you can re-enroll in a university by the following semester and get your credit load up, we will not deport you. We'll give you this deferred action for a period of maybe 3 or 4 months. Why? You had your student visa. Due to a natural disaster, you lost it, and then you'll get your student visa back in a couple months. This was the archetypal use of deferred action. What I've said is a bridge from one status to another. In other words, at the other end of the rainbow, a pot of gold was awaiting the immigrant. With DAPA, there is no pot of gold at the other end of the rainbow. After the 3-year period, this 3-year deferred action, the immigrant is in the exact same place they started with. This is not meant in any respect as a transitional program. Rather, it's meant as a way to bypass it. I'll tell you what's going on here, folks, right? The president was hoping that Congress would pass some sort of immigration law, and this policy would bridge the gap till then. Who the hell knows what the election is going to happen in a few months, but the prospects of immigration reform are far bleaker today than they were perhaps in 2014, right? So I've argued in my Cato brief and elsewhere that this policy is not an effort to execute the law in good faith, but it's really an effort to bypass the law the president had sought to repeal. And for these reasons, I posit that this is actually an unconstitutional suspension of the law, and I hope the Supreme Court addresses this issue, as I'm sure we'll discuss in the Q&A. I doubt they will due to the current posture of the court with their less than full house, but this is something that I hope that at least some of the justices will address. Thank you so much.
Thank you. Thank you. I'm going to stand if that's okay. You mind?
Yeah.
I just said I'm not used to talking while I'm sitting. I want to thank Professor Blackman for coming all this way to help us to raise this issue. Let's talk about it. We greatly appreciate it. So it's a long way for you to come. And
Thank you. I appreciate it very much.
Thank you, and thank you to the Federalist Society for having us. Okay, so look, the take care clause doesn't come up very much. I don't know if it's coming up in your conduct class. It's not used very much until now. You're trying to make an innovative argument. The key word there, the clause reads: the executive shall take care that the laws be faithfully executed. So the key word there is faithfully. Right? The Congress considered all sorts of different permutations. They consider having a provision that said the president shall take care to execute to the best of his abilities. And no, I don't want that. I said the president shall take care to duly execute. No, we don't want that. Instead, they consciously chose to phrase it in terms of the president shall faithfully execute. So whose faith, if that's the key word? It's not the faith of Congress. The president is not an agent of Congress. I think that's one of the key things to understand here. Right? When the framers set up the government we have here today, they created the president as a coordinate equal branch with the president. So the president doesn't is not bound to execute the law the way Congress would want. Instead, the president is bound to faithfully execute the law in the eyes of the American people. And the president's been entrusted with exercising that faith and interpreting that faith. And the president has to answer at the end of the day to whether or not he or she has executed the law according to what the people want. And there's a place to answer for the president to answer to whether or not he or she has executed the law faithfully. And that's the ballot box. It's not the courtroom. It's not something that can be judicially analyzed or judicially enforced, because in the day, the president is constitutionally obligated to do what he or she thinks is correct in terms of enforcing the law. And then if the American people think that that's not the faithful application that he or she was entrusted with, then that will be reflected in the ballot box at the end of the 4 years. So that's the whole system of checks and balances we have. In other forms of government, like in Britain, the Congress has an enforcement arm on their own. Congress actually enforces the laws themselves. It's much more efficient. It's a much better way of getting things done. But our whole system of government is designed to actually check Congress. And so if the president feels that the law has to be executed a certain way, even if Congress thinks that's absolutely 100% dead wrong, even if Congress wants him to do more or less, unless they pass some sort of actual legislation directing him or her to do that, and even with that legislation, query whether it violates the take care clause, because the president has the right to stand up to Congress and say, I'm a coordinate branch, I'm equal to you, this is not the way the law should be interpreted and enforced. So when the president and Congress disagree, there's nothing in the Constitution that says that Congress view trumps. So, everyone always disagrees, someone always disagrees with the president, right? There's always members of Congress who think the president should be doing more, should be doing less, should be doing this, should be doing that. With the commander-in-chief, the president has the obligation to be a commander-in-chief and defend us. Well, every time the president exercises his or her commander-in-chief powers, people second guess that. You should have invaded there. You should have invaded there. You should have invaded with the Marines. They should have gone in earlier. Should have gone in by land. Should have gone in by sea. Should have used fighter pilots. If you allow every single decision by the president to be second guessed by members of Congress, he or she will be in court every single day. You didn't take care because I disagree with the way you executed your duties. There will literally be a case filed every day if members of Congress can say, I disagree with the way you are enforcing our law. Granted, reasonable minds can differ about it, but that is why it's a political question, not a judicial question. That's the way the courts have treated it. I don't know a single case above the trial level where any appellate court has actually used the take care clause to second guess the president. I'd be interested to know, but I'm not. I don't think.
I'll mention later. Yep.
I'm not aware of an appellate case ever where the courts actually said, you know what, Congress has the right to disagree with you here about how you've actually enforced the law. Even if the president decides not to enforce the law at all, that is his or her constitutional prerogative if the president feels it's unconstitutional to enforce that law. And if that's not a faithful execution, then he or she has to answer to the people at the ballot box for that. But you can't have a court case every day. A congressperson thinks that the president's not doing his job, because then the whole system will shut down with case after case after case every day. And that's why our system is designed the way it is, with political accountability. And in this particular respect, the accountability is not judicial in nature. Let's talk about DAPA for a minute. So DAPA, there are about 11.3 million people in the United States right now who are undocumented. So 11.3 million people. Congress provides about enough money and resources to deport about, at best, 400,000 people a year. Okay, so the president's got to decide. I've got 11.3 million people here. Physically, at best, I can only deport about 400,000. All right, a tiny, tiny fraction. So the president has to go about deciding who to deport and who not to deport. Obama has deported more people than anyone in history, right? We can argue whether that's good or bad, but the simple fact is he's deported about 25% more people than George Bush. He's deported about almost 2.5 million people. So he's taking that 400,000 a year and he's doing it every single year he's been in office. You can take the number of people that George Bush's father deported, Herbert Walker Bush, add to that all the people that Clinton deported, add to that all the people that Nixon deported, all the people that Reagan deported, all the people that FDR deported, all the people that Lyndon Johnson deported, all the people that Kennedy deported, all the people that Hoover deported, and all of those presidents combined have not deported as many people as Obama. So to sit here and say that he's not taking care to execute the deportation laws is really kind of crazy. Yes, members of Congress might disagree with who he's deporting. I mean, I don't. He's going after the people who have criminal backgrounds. He's prioritizing the people who have violated laws or violated immigration laws or pose some sort of danger. But of course, someone can disagree with that if they want, but they have to disagree with it at the ballot box. They can't literally sue him because they wish he would have deported Fred and not Mary, or Tom instead of Jane. It's really inconsistent with the way the system works to open him up to that. So deferred action, Obama didn't create it, right? It's been around since the 60s, and every president's been doing it. Reagan used deferred action for hundreds of thousands of individuals. Brian Cunningham looked it up. John Lennon apparently was the first person who got deferred action. He was technically deportable, but we decided he really shouldn't go. We
Deport Yoko.
Yeah. We needed him too much, and so he was deportable, but the federal government decided not to deport him. At the end of the day, all that DACA does not create substantive rights. Right? All DACA is a situation where Obama is being transparent, like prior presidents, about who he's prioritizing and who he's deciding to deport now and who he's not deciding to deport now. And that transparency, announcing to people, look, you are a category of people that I have no intention to deport. There's nothing unconstitutional about that. There's nothing, that does not constitute a failure to execute the laws, to exercise prosecutorial discretion. He's got to, because he cannot deport all the people that are deportable. He must exercise discretion. So the question is, do you want him to do it? Is it unconstitutional for him to do it in a transparent way? Is it unconstitutional for him to be upfront about who he's supporting and who he intends to deport? Or does he have to hide the ball and say, well, in order to look like I'm following Congress, I have to never announce who's going to be deported. I have to just act like I'm making it up as I go along every day. The benefits of DACA and DAPA are, the benefits of being transparent are there's a multiplicity of benefits. Because of DACA and DAPA, well, DAPA has never gone into effect, but because of DACA, and DAPA would be the same if it was allowed to go into effect, you have hundreds of thousands, millions really, of individuals who are going to identify themselves for the government. They are going to come out of the shadows and provide their addresses, and that is going to help enforcement down the road. It's also, if we need to identify and reach out to these people for any reason, because they're a witness to a crime or because their status changes, we now know where they are. That's the benefit of being transparent about it. Also, we tax them. If they actually are allowed to work legally as opposed to illegally, we get the benefit of the Social Security taxes that they pay. Now, yes, they should be entitled to Social Security benefits since they're paying in the system. But Obama's made a decision that if I'm transparent about who I'm going to deport and I allow them some knowledge of what? You need to talk to me right now? Okay.
I'm sorry.
I'll cover it. I'll finish his argument.
Yeah, no.
So I actually agree in terms of policy. So in terms, this is a first. I actually had a professor who was giving a class once, giving a review session, and in the middle of the class, a staff from the school knocks on the door, and she's like, "Your wife's going into labor now." So he was like, "I'm out." And that's actually David Bernstein at South Texas. So I'll finish Professor's argument. So yeah, it's indeed true that by bringing these people out of the shadows, there's probably an economic benefit to the state, as well as allowing these people to pay taxes. Or actually, the truth is they're already paying taxes with illegal Social Security numbers. So now they'd actually pay taxes under their correct Social Security numbers. So it's actually an improvement. Okay. Have I sold enough? Can you want to continue?
And I'll wrap up really quickly
I'm gonna let you finish.
I want you to. Right. So that's my spiel, right? I mean, Obama is enforcing the immigration laws. He's enforcing it in a way that he deems that is faithful, according to his interpretation and the American people's interpretation that put him there. If he's wrong, then we'll have a change of policy and a new president. That's a political issue. He's doing the best he can with the resources he can, but the benefits of being transparent are, he has decided, that outweigh the benefits of being obscure about it. Now, just some real quick responses. So Professor Blackman said his decision not to deport certain people amounts to a suspension of the law. I disagree. The president can't always enforce every law to the hilt. If a prosecutor decides not to prosecute someone for murder, okay, the president says, you know what, in your circumstances, I just don't think it's appropriate to go after you for whatever reason. I don't know the time or the money, or I think it was justifiable, whatever. Prosecutors have the right not to prosecute someone. It doesn't mean they're suspending our murder laws because in an individual situation, they're not going after a particular person or even a group of people. To say that they're exercising their discretion not to prosecute does not amount, from a legal point of view, to a suspension of that law. It's very interesting when Professor Blackman said he's trying to do something that Congress essentially rejected. But that's not, I don't believe that's right, because Congress did not reject what Obama's doing. Congress considered it and failed to pass a similar law. That's true. But just because Congress doesn't pass a law doesn't mean they've issued a clear, explicit mandate prohibiting the president from doing something similar. I mean, Congress doesn't do thousands of things every day. I don't know if you've noticed. They don't do a whole lot, right? They do very rarely do they actually do something. So there's thousands of times where they choose not to do something. You can't have a system of government where every time Congress considers and fails to do something means the president can't do it. Now, if Congress had passed a law that said, we demand that you deport these people you're refusing to deport, then it'll be a head-on clash between what the Congress explicitly is requiring and what the president is doing. Then I think it'll be an interesting constitutional question. And I'm not sure what happened because they're both coordinate branches. But we don't have that. We have a situation where Congress has failed to act and the president is there and they're stepping in and enforcing the law in a way which is faithful according to his political mandate. In terms of Obama's motives, I mean, I hear your story. I mean, it is an interesting narrative, and I see the power of it. Congress considers this, they failed to do it, he steps in. It does look like Congress is trying to circumvent in some respects. I get it, I see that, but it's not the test. The test is not why Obama's doing it. The test is Obama faithfully executing the laws? And the answer is yes, in all sorts of ways he is. And you can't second guess his motives in this way, because if you could, every single time the president ever does anything, he will be sued or she will be sued. And that is not the system of government we have. It's a political question, not a judicial question. So the question is not why he's doing it. The question is he actually executing the law faithfully? And the answer is, I think, clearly yes.
Look at that. And this takes concentration to stop, be interrupted, come back, resume your thoughts. That's very commendable. So I thank my dear friend Professor Jones for his first kind remarks. I'll raise a few issues in response. So in terms of has a take care clause been brought up by the Supreme Court, it has. One of the first cases decided was a case called Kendall versus X. Rel. Stokes, which originated from the administration of President Andrew Jackson. This goes way back. So to make a long story short, there was this company that the government owed money to. President Jackson said, I don't like that company. So he told his postmaster general, don't pay that company, okay? The company went to court and sued and said, hey, look, we have these credits. We have this money coming to us. And the Supreme Court actually held, right? The court actually held that mandamus was warranted, okay? And the court wrote, to contend that the obligations imposed on the president to see the laws faithfully executed implies a power to forbid their execution, is a novel construction of the Constitution entirely inadmissible. So indeed, the take care clause has been brought up. It's been cited in a number of cases, most prominent of which was Youngstown, right? We all remember Youngstown, our favorite steel seizure case. As we recall the facts in that case, President Truman asserted the authority to use the power of eminent domain to take over the steel mills. Okay. Now he cited this as an incident to his commander-in-chief power, that he had the power to, to prosecute a war. Ask yourselves, has Congress had given that authority? It's an open question for Korea. But did the president have power to administer that war? The court rejected that authority of power. They said, you are not a lawmaker. And indeed, in signing the take care clause, they said, this prevents you from being a lawmaker to actually make law. The take care is cited in a raft of other cases. You can read my brief if you like, but I'll stop there. So second, in terms of the suspension, I didn't go into too much detail, but what's actually going on here is not just this granting deferred action, but the government memo says we are granting what's called lawful presence. Lawful presence. And is this for you? No. Okay. No more interruptions.
I'm off the hook.
You're off the hook. This is a granting what's called lawful presence. So effectively, it took 4 to 5 million people who were not here lawfully and granted them lawful presence. Pay very close attention when the case is argued in 2 weeks, how the government explains this lawful presence. They have no response whatsoever. Another point to respond. I've always seen this thing that Barack Obama is the deporter-in-chief. I need to caveat that number. There's 2 different numbers here, the number of removals and the number of deportations, okay? The number of deportations are court-ordered. On that respect, when a court orders President Obama to remove someone, he does. But with respect to removals, that is, people found at the border and sent back by the government, that number is plummeting. So in fact, the discretionary removals by President Obama is much lower than George W. Bush. What's really high is the number of court-ordered deportations. I think that's an important point to stress. I think Barack Obama actually likes the moniker deporter-in-chief because it helps justify these executive actions in immigration. The next point is, has Congress actually voted against this? Yeah, right. By not voting for a bill, that's saying we don't want it, right? By not voting for a justice, that's saying we don't want it, right? Congress can do stuff by not voting on it at all. That's actually a very significant point. But more to the point, the House of Representatives passed a resolution specifically saying that DAPA is unconstitutional. The House voted on a resolution saying that this is unconstitutional. So in terms of Youngstown Zone 3, probative evidence. Now, people say, well, what about the ballot box and what about the power of the purse? The way DAPA is funded, Congress can't defund it. DAPA is funded 100% by user fees. In other words, people pay an application fee, which are frankly often waived, but people pay an application fee to get through this. Even if Congress shut down the Department of Homeland Security, DAPA, like Keith Richards, will live forever. You cannot stop it. In terms of electoral accountability, I stress the fact this was announced 2 weeks after the election. That is very significant. Lame duck, right? There was no accountability for this, and it was done deliberately. So it could go. Luis Gutierrez, who's a representative from Chicago, was begging the president to announce this before the election because it would help with the turnout. The president said, no, I'll wait. Now, the final point I want to raise. Now, it's certainly the case that if a prosecutor decides, I don't want to go after this guy for murder, that would not be suspension. But we're not, I think Professor Jones actually said, in an individual case. And that's the key word. Now, let me ask a couple questions for all of you. How many of you have ever gone above the speed limit? Be honest. We all have, right? Now, were you worried about a ticket? Maybe, maybe not. Thanks to Chicago speed cameras, I think I got a ticket this morning. You're going 30 hours in a school zone, whatever. But imagine if the sheriff in your town, right, said, okay, we have limited resources. The speed limit's 65, but I'm not going to pull you over until you hit 80, right? He announces this. How many of you will be fine driving 79? Admit it. Come on. He said, until you go 80, okay. You guys perhaps more honest than I am. When the president or the chief executive announces in advance that he will not enforce the law as to an entire class of people, it distorts incentives. The legislature of your town said, we want the speed limit to be 65 because we don't want people speeding. By the president saying, you know what, I won't pull you over until at 80, it destroys the expectations of the parties. And indeed, I must respectfully disagree. The president is the agent of Congress. He shall take care of the laws are faithfully executed. Who enacts the laws? Congress. We have something called the non-delegation doctrine. Congress delegates authority to the president. This is not a case of the president's acting on his own independent Article 2 powers. Not the case. Every ounce of presidential power the president has here comes from Congress. And you know what? Congress will tell the president how to execute it, and that's not being done in this case. Thank you very much.
Okay, so the resolution doesn't. The fact that that some members in the House think that Obama is exercising this particular discretion or prosecutorial discretion, the fact that that's some of even the majority of the members of the House disagree. Again, it's not the test. There's always going to be members of the Congress who disagree. The bottom line is Congress actually passed legislation with Congress, Senate, and the House together passed binding legislation that said Homeland Security shall establish national immigration enforcement policies and priorities, right? 6 U.S.C. 2025, and establish such regulations and issue such instructions and perform such other acts as he deems necessary for carrying out his responsibilities. They have given him the legal authority to execute this law. And a wide range of, the fact that some of them may not like the way he's doing a particular case is always going to be the case. If that's the basis for a lawsuit, there's going to be a lawsuit every day. So the test isn't does 51% of one branch of Congress disagree, because then you're always going to have large numbers that disagree, and so that's why it's a political question. In terms of what the definition of lawful presence means that they're deciding not to deport you right now. Unfortunately, I wish it meant more, but it really doesn't. Now you get a 3-year term. Well, DAPA's not in effect, so you get a 2-year term. So for 2 years, you get a promise that they won't deport you. But it's not clear whether that promise is legally enforceable, unfortunately. And if Trump wins, it's not going to be legally enforceable. And the problem is, from my perspective, Trump's now going to know where hundreds of thousands of people are and where they live.
And their biometric data.
And that's all because people self-identified themselves as part of DACA. I mean, so lawful presence means you have been deprioritized for the moment. And unfortunately, from my perspective, it doesn't really mean anything more than that from a legal point of view. If it did mean more than that, then you could argue that Obama's making law and not just exercising discretion how to enforce an existing law. Discretion that he's been given to Congress through an actual law, and that Congress has to pass a new law if they want to actually change the way he's exercising discretion he was given by them. In terms of so the Youngstown sheet, Youngstown sheet was a situation where Congress actually had a law that contradicted, not a resolution. I think it's an interesting constitutional question. If Congress, there was one situation where Congress passed a resolution where Clinton was tried to bomb, right? And they tried to pass a resolution, almost passed a resolution when Clinton tried to bomb former Yugoslavia. That would have been interesting if that train had hit, because then you'd have a resolution directly contrary to commander-in-chief powers. And they tried to pass an actual law prohibiting from doing that, but they couldn't. I think it'd be interesting to see constitutionally what happened if you had a direct congressional law that went against what the president is doing. At that point, I would tend to take the president's side myself, but reasonable minds could differ. I really disagree, though, that the president is ever the agent of Congress. I mean, I guess it's a philosophical difference to some extent, but even when he or she is executing the laws, there's a reason why the framers gave that power and responsibility to the president, not to Congress. They wanted efficiency. If they wanted a true agent, they would have had a parliamentary form of government where Congress had their own enforcement mechanisms. The reason why they bifurcated the government or trifurcated it and balkanized it and gave the president the authority to enforce is because they did not want an agent of Congress to be enforcing the law. They wanted a check on Congress, someone who could push back and enforce it in ways that the American people were comfortable with. Not Congress, but the American people are comfortable with. It's not very efficient. I know it breaks down a lot of times, but that's what they wanted because they felt we'd all be more free and have more rights if the government moved more slowly.
Thank you so much. All right, and we got about 18 minutes for questions, so I welcome them to the floor.
When you said that removal numbers have plummeted, that related to the border security that they have implemented?
So the issue is, okay, so again, there's two different types of numbers, right? One is court-ordered removals, and those are sky high. That's when an immigration judge actually orders removal. The second is when a person is apprehended at the border, at or near the border. The policy of the Obama administration has basically been to parole these people, to let them stay with family members, to keep them in detention centers, not to remove them on their own initiative. So those numbers have declined significantly. There was actually a footnote in the Fifth Circuit's opinion in Texas, U.S. that addresses that. I don't have the numbers in front of me. If you check that, there's a footnote about it, and I'll spell it out very clearly. I'm sorry if I don't have the numbers handy for you. Yes?
About the removal question. So if I'm understanding this correctly, the removal numbers under the Obama administration have decreased. Well, what exactly does that mean if people are coming from across the border into the U.S. territory, they're caught?
They're apprehended and released. They're basically apprehended and paroled.
And released to where?
Family members, other
In
places.
the United States or in Mexico?
In the United States.
Okay.
I mean, again, this is not my area of expertise, but there have been a number of states. The Border Patrol Union has been actually very outspoken, and they've claimed, and you can take the photos worth, that they've been given orders not to detain people, not to remove them. But again, this is not my area of expertise. If you're really interested in this issue, there's a footnote in the U.S. v. Texas opinion. I can pull it up after the discussion. I'd be happy to give it to you.
Thank you.
DAPA stands for what again?
Deferred Action for Parents of Americans. It's actually DAPA, right? It's Deferred Action for Parents of Americans and Lawful Residents, but just DAPA is good enough.
So you provide a better analogy then from speeding to separating families, because I think those are very distinct things. Speeding being a personal choice and it's just impacting one person, right? Versus you're taking a parent away from his or her children. So I guess I'm trying to follow your argument, but you got me there because I don't understand how speeding impact that just doesn't work.
Right. So it's to understand this, you have to understand the situation of how Congress viewed this, right? So in the 1960s, was the Immigration Nationality Act. The Immigration Nationality Act of 1965, there's this very good discussion between Senator Kennedy, Robert that is, and Senator Sam Ervin, who's involved in Watergate. And they were discussing the issue of birthright citizenship. And they were saying, we don't want this to be where a person comes here as a baby, and then the baby can petition for the parent citizenship. So they imposed a significant number of gaps to keep families apart, right? One of them, which is a 21-year period. They must wait till the child turns 21 for an adjustment of status. Additionally, it's something called a 10-year bar, where if you're in the United States for more than 1 year legally, you actually need to leave the United States for 10 years and then apply for consular adjustment abroad. So Congress imposed up to a 3-decade gap denying family reunification. So this isn't something I'm making up, whatever. Congress for many years has said, if you're a U.S. citizen and your parent is not, you may have to wait 30 years to be reunified. I'm sorry, was your question? Yes, sir.
Quick point and then a question. The political question, I mean, as Professor Jones stated, it was first used deferred action with John Lennon in 1971 when Richard Nixon was in office. Again, in 1986, the Immigration Control Reform Act, which President Reagan signed into law, it specifically mentions deferred action as a tool that can be used by the executive, even though the INA specifically says any person here unlawfully shall be deported. It doesn't mean every single person right this moment shall be deported. Congress recognizes that there are limitations on it. And as you mentioned, President Bush with deferred action for a group of persons for the first time, the victims of students of Katrina. And then again, deferred action was used for widows and widowers of spouses of American service persons. And the state of Texas had no problem with that. But now that they want to use it for a different purpose, even though it's been perfectly lawful for all these years, if they want to use it for a different purpose, Texas stands up and cries foul and says no. Clearly, it strikes me as a political question, and we all know that political questions should be decided by the people, not the courts. That's my own personal comment.
Now the question, right?
Now the question is, it has to do with what you mentioned, and it goes back to the speeding tickets on, is there discretion or is there not? If there is, it probably is prosecutorial discretion. If there's not discretion, then maybe this is unlawful. But the government proposed and actually leased a place in Crystal City, Virginia, 280,000 square feet. It would house 3,100 new employees, as well as employees throughout the country in field offices. Whose sole job would be for review every single DAPA application that comes through one by one by one by one by one, and decide whether or not that individual person is granted deferred action or not. And that is clearly, to me, prosecutorial discretion. It's the same thing. And I don't know how the state of Texas can say that that's not discretion when they're spending tons of money. And it's, as you said, it was self-funded by the people who were actually being evaluated themselves. And certainly, I don't think anybody disputes that if Donald Trump is elected, that day he could suspend this whole program. So I think it's prosecutorial discretion.
Inflect your voice up so this actually sounds like there's a question. So what do you think, right? Or could you comment on it? Right. So I appreciate it's actually a very, very well commented statement. It actually goes before John Lennon. It actually goes back to Eisenhower, if you want to be precise. It wasn't called deferred action. There was a different name for it, but it actually goes back to President Eisenhower. So if you're interested, I wrote a piece in the Georgetown Law Journal Online about the history of deferred action. You're welcome to read up on it if you like. The short answer is deferred action is not the problem. I don't have the problem with deferred action. The key fact is it must be consonant with congressional policy, okay? It must be consonant with congressional policy. So to use a few examples, now he's going to respond, right? Sorry, I didn't throw you. You know, when I say something and I make a press, shh, you know, it means I'm doing something wrong. No, or right, I don't know. So the short answer is in the past, whenever deferred action was used, it fit into this bridge construct. So use President Reagan, President George H.W. Bush's example. It was ancillary to the statute. So for example, President Reagan and President Bush enacted the statute. I'm sorry, President Reagan presided over the statute that gave a significant number of aliens amnesty. Okay, they got a green card, and after a number of years, they could apply for citizenship. What about their family members while they were going through the application process? They were subject to removal. So what Reagan and then Bush did was said, okay, in like 3 or 4 years when you get your green card and then you can adjust your relatives, you'll be fine. We will just defer them for these couple of years. In every case, deferred action has been ancillary to some sort of statutory reform, or it was some sort of temporary bridge. The key fact here is that deferred action is not being used in this sort of bridging manner. It's being used what I've called a tunneling manner to get around the law the president doesn't like. Now, in terms of Crystal City and employees, the court in Brownsville, the district court, asked the government to provide a single example of a person who was denied relief under DACA for discretionary reasons. A single person who was denied for purely discretionary reasons. You know how many they found? 0. The government can identify a single person who was denied for discretionary reasons. That is, perhaps people didn't meet the criteria. They didn't graduate high school, they weren't here a number of years, they had a criminal background, whatever. But not a single person received the benefit of any sort of discretionary denial. And there's no reason to think that the 1,000 employees in Crystal City would behave any differently because DAPA was designed to be, quote, similar to DACA. So indeed there's discretion, but this is not a policy designed for use of discretion. This is akin to, I will not pull any of you over unless you go, 81 miles an hour. Now, Professor Jones, I realize you had some of those.
Yeah. No, just real quick. I mean, I don't agree with the characterization of DACA. I mean, it's true that their discretion was exercised in things were laid out in a very detailed and meticulous manner for what they're supposed to consider. But just because they have clear standards doesn't mean it's not discretionary. And for DAPA itself, which has never been instigated, it's up to each individual officer as they're being instructed as a general policy matter to decide whether each individual poses a threat to national security, poses a threat to border security, whether they have felonies, if they have misdemeanors, they're in a gray area, whether they have ever broken their visa status. I mean, there's all these areas that they have to analyze case by case. Now, they might end up having a matrix of very complicated standards that have been imposed from on high that help them figure out how to do it. But just because it's worked out doesn't mean it's not discretionary.
Okay. I think I saw a question there also. Yeah, yes, ma'am.
I was just gonna comment. I was actually there, not on a 8th year, with the Dreamers. I was volunteer with ICER, and with Professor Jones, you said that they voluntarily, basically they give out their information to where they live, where they work, and a lot of these undocumented parents don't really reveal their identity, especially if they overstay their visa or are not registered lot of the clients that were there without lawyers didn't really know that, okay, well, after those 3 years, you really don't have that pot of gold, and then, after those 3 years. So my question would be, what if President Obama, or I guess the next president, if they did want to change this or adapt something new, what do you think would come out of it?
So let me answer the question this way. So I haven't really talked about the Supreme Court yet, but we are now in a situation where we're at 8 justices, as I'm sure you're all well aware. In the event that there's a 4-4 affirmance, which is distinctly possible, that affirms a judgment of the Fifth Circuit, which means that DAPA does not go into effect, and this goes back to the lower court for a trial. Now, let's say there's actually a 5-majority justice, 5-majority block who says that DAPA is lawful. Okay? Ask yourself this question. It'll take probably 1 to 2 months after the court decision to actually ramp up to hire all those people in Crystal City. If you're an immigrant, and it's like, let's say, September or October of 2016, and Donald Trump is Republican candidate and he's actually beating Hillary Clinton in the polls, do you think anyone in the right mind would sign up for this? No. That's why this entire case, as Professor Jones said, ought to be decided by the election, right? Regardless of what the court does here, the next president will decide whether to implement DAPA, expand it, or rescind it. So I think it's very unlikely that you see any action whatsoever on this between July and November. Because once the election happens, everything's going to change. I mean, if it's Clinton, yeah, they'll start applying, but people are going to wait and see what happens. So another hand somewhere here. Yeah. Yeah, you.
And just for commentary purposes, so you posited that because there were apparently 0 cases that the government was able to cite as being discretionary, where discretion didn't work out for the applicant. With DACA, which is the middle part of DACA, is that it's children, so they haven't reached majority. They're less likely to.
Well, they all have at this point.
What's that?
But at this point, they've already reached by the time they applied, so it's a graduate from high school, so they're basically all majority age.
Okay, but I guess the point is that that's an entirely different community than the would-be DAPA applicants who have had much more time to potentially not get to be discretionarily prosecuted because they have a criminal record or because they X, Y, or Z against the factors that would disallow them DAPA protection. So to say because DACA we're not able to cite any discretion, that's likely how the government would just rubber stamp DAPA applicants is patently false just in its formula alone, because those are 2 patently different communities that you're talking about. That would be like saying my daughter's preschool class don't have any speeding tickets, therefore it's unlikely that this class doesn't have any speeding tickets when we have much more of a ability to offend. So it's 2 entirely different communities, so I'm not sure that driving that or concluding that is even logical.
It's a very good question. I think the response has to be based on the criteria of what's granted. There is no room for discretion, right? It's not that the agents aren't exercising discretion. The way the policy is structured is they have no room for discretion. There's basically a checklist. You meet this, this, and this, it's a grant. There is no room for a person to consider whether someone's a good person, whether they deserve it, fairness. These are traditional characteristics that go into law enforcement and enforcement. Those are not permitted. In fact, one of the reasons why DACA was implemented was because the president found that his subordinates, right, the line agent officer, was not enforcing his priority. They were using their own discretion. DACA and indeed DAPA were designed to eliminate any line agent discretion. They're saying the discretion is now decided by the secretary from up on high, and I think that's inconsistent with what discretion historically has been.
Well, I just disagree. I mean, the DAPA itself says that they will only grant DAPA to those who qualify and do not fall in any of the enforcement priorities and, quote, present no other factors that in the exercise of discretion makes the grant a deferral action inappropriate. I mean, now you can argue that they won't actually utilize that discretion, but DAPA has never been affected, so you don't know. So you're just basically preemptively saying, we don't think you'll actually use discretion, so you can't do it. Now, you can argue that they weren't using much discretion in DACA, but DACA didn't have that particular hook. And also, in DACA, I just disagree that with the discretion, I think there is discretion, but it's coming from above, not from the individual caseworkers. So even though the individual caseworkers are locked into a bunch of guidelines, doesn't mean it's not discretionary. Is my point, my argument.
Okay, we've got a minute left.
I mean, you guys are welcome to ask questions out there. I think there's a class here right
We have a
now,
class,
but-
guys, so thank you all very much for your time.
Thank
Thank
you
you.
so
Well prepared. Appreciate that.
Thank you.